The Supreme Court makes us wait another day to decide executive powers. Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Today the Supreme Court punted for one more day on two major cases concerning executive powers of the president. One case involves an executive order and the other an executive agency. We're going to give background on both cases and talk about the limits of executive powers according to the Constitution. Stick with me to the end because I'm going to talk about what Congress has for too long let the executive branch get away with and what's wrong for that. Before I begin, I do want to shout out to the sponsor of this channel, which is Conservative News and Views, link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of good merchandise there, including this t-shirt that I'm wearing. Can you read it? Rhino hunting. And that's directly relevant to at least one case that I will discuss today. All right, ladies and gentlemen. Constitution 101 is back in session. But first, a Supreme Court update. Today, the court released two of the 4 opinions left on its docket. One case concerned the mess resulting from the failure to disestablish properly the Creek Nation Reservation in Oklahoma. That's the case of McGirt versus Oklahoma. Technically, that reservation still exists and covers most of eastern Oklahoma, including Tulsa. Now, in 2015, a negligent father stood trial for child neglect in the case of his daughter, a Cherokee. In light of the McGirt case, this man argued that only the federal government had authority to prosecute him. The Supreme Court held that in fact the federal government shares jurisdiction with state governments over crimes in which one party is a Native American and the other is not, that happen in Indian country. That's Oklahoma versus Castro Huerta, 21-429. The other case involved a U.S. Army Reserve veteran, a state trooper, who went to Iraq when the Army deployed him there. While in Iraq, he was exposed to the fumes from toxic burn pits that incinerate all manner of trash in one pile. He returned home with constrictive lung disease and asked the Texas Department of Public Safety to give him a desk job. They refused, and he lost his job. That's not supposed to happen under the Uniformed Services Employment and Reemployment Rights Act of 1994. That's U.S. ERA. The trooper sued in the Texas courts. The trial court refused the state's motion to dismiss, but a Texas appeals court reversed that and dismissed the complaint. They cited the sovereign immunity of the state of Texas from lawsuits under U.S. ERA or any other such mandate. Today, the Supreme Court said Texas surrendered sovereign immunity in any exercise of Congress power to raise and support armies. Kavanaugh and Roberts both swung with the liberals to fine for the trooper. Justice Thomas, in his dissent, questioned whether unfunded mandates and standing for private employment suits are valid exercises of the war-making powers. Torres versus Texas Department of Public Safety, 20-603. The Supreme Court, at about 10:30 a.m. Eastern Daylight Time, designated Thursday, June 30th as another opinion issuance day. The two executive powers cases at issue are the only two cases left for the court to decide on this term. So much for those other cases. Now we get to the meat and potatoes of today's discussion, executive powers. The Constitution defines the powers and duties of the President. These come from Articles 1 and 2 of the Constitution. Now, his chief Article 1 power is the veto, which Congress may override. Beyond that, he has the treaty-making power, subject to 2/3 Senate ratification. The President also has the appointment power, subject to Senate confirmation, except that he can fill vacancies temporarily when Congress is in recess. he also has the reprieve and pardon power, and in this he answers to no one. But he does not have the power to make law. And while he may grant reprieves and pardons, he may not try or convict someone. These limits should apply to every agency of the government under the president. Traditionally, they have, except for the unique power of the military to try and convict its own by court-martial. But successive presidents have abused the executive powers and assumed the authority both to make law and to convict people. A president has two methods for this kind of abuse and accession of executive powers. First is the executive order. By tradition, an executive order should set policy within the executive branch, meaning for executive departments and agencies. But we have lately seen executive orders that clearly encroach upon the powers of Congress. The case of Biden versus Texas 21-954 raises this very issue. President Trump declared that those applying for entry visas from Mexico should remain in Mexico while the authorities are processing their applications. A particular federal law, Title 8 United States Code, Section 1225, governs the handling of such cases. President Biden, through the Secretary of Homeland Security, canceled that remain in Mexico requirement. The state of Texas sued the federal government over this. In the latest action, the Court of Appeals for the Fifth Circuit held the Secretary of Homeland Security had no authority to end this remain in Mexico policy. In December of 2021, the president took it to the Supreme Court, which granted certiorari. The case has seen a dizzying number of friend of the court briefs in addition to the petitioners and respondents brief. Even after oral argument, the court asked for more briefs. Interestingly, they asked for these supplemental briefs on the very day of the great leak in the Dobbs case. The latest action came on June 6 in the form of statistical corrections to some of the government's supporting documents. Now, the other executive powers case has received far more attention. West Virginia versus Environmental Protection Agency, 20-1530. At issue here is a supplement to the Clean Air Act, Title 42, United States Code, Section 7411D. This law sets forth some of the powers and duties of the Environmental Protection Agency, or EPA. As such, it represents a delegation of legislative authority to the EPA by the Congress. The real issue before the court is whether the EPA exceeded its authority. Here is the relevant text of that law. 1. The administrator shall prescribe regulations which shall establish a procedure similar to that provided by Section 7410 of this title, under which each state shall submit to the administrator a plan which, A, establishes standards of performance for any existing source for any air pollutant, 1, for which air quality criteria have not been issued or which is not included on a list published under Section 7408A of this title, or emitted from a source category which is regulated under Section 7412 of this title, but 2, for which a standard of performance under this section would apply if such existing source were a new source, and B, provides for the implementation and enforcement of such standards of performance. Regulations of the administrators under this paragraph shall permit the state in applying a standard of performance to any particular source under a plan submitted under this paragraph to take into consideration, among other factors, the remaining useful life of the existing source to which such standard applies. End of quote of the law. Now, the text of Section 7411D goes further if a state refuses to submit such a standard of performance plan, the EPA may do it for them. This also applies if the EPA administrator deems a state's plan unsatisfactory, which is another problem. Only the administrator decides satisfaction of a state's anti-pollution plan. This case consolidates 3 other cases, and its argument has spanned 2 terms, or rather its briefing has spanned 2 terms. The Supreme Court must decide whether or not the Congress, number 1, meant to authorize the EPA to declare something a pollutant and make rules with no limits other than cost considerations, and number 2, had the authority under the Constitution so to act. Now, before we get into the particular pollutant that has blown up to a Supreme Court case, I want to shout out to another sponsor, BitNext. This is your replacement for Zoom, Slack, the Google G Suite, Microsoft Office 365, Dropbox, WeTransfer, and Chili Piper, among others. Unlike any of them, BitNext protects your content and conversations so well, even the administrators can't see them. So this is your channel for secure comms, conferencing, cloud storage, and file sharing. Best of all, everything is back-end, so you don't even need client software. If you have a browser, you can use BitNext. Follow the link and give them a try. 28 days free of charge. You can't beat that with a stick. All right. Are you ready to talk about that air pollutant? The particular air pollutant at issue makes the issue an order of magnitude worse. It is carbon dioxide, the same gas plants breathe in to make sugar, starch, or cellulose. Carbon dioxide, say some, is a greenhouse gas, present in dangerously excessive amounts in our atmosphere. And if we don't take carbon dioxide out of the atmosphere, they say, Earth's weather will grow fatally stuffy. On that ground, President Barack Obama declared carbon dioxide a pollutant. In 2009, he submitted to Congress a cap-and-trade law for consideration. Then Representatives Henry Waxman of California and Edward Markey of Massachusetts, both Democrats, agreed to shepherd this through the House of Representatives. Then Senators John Kerry, also of Massachusetts, and Barbara Boxer, also of California, also both Democrats, did the honors for the Senate. In the middle of these deliberations, the Climategate story broke. I'm going to leave a link in the description to an article I wrote about that scandal 2 years after it first broke. Now here's the thing that I want you to take away. For a critical period, climate skepticism was a big thing. Then, a week or so after the story broke, came the 15th Conference of Parties to the United Nations Framework Convention on Climate Change. Well, this story effectively blew that conference up and killed the deal these parties were conferring to make. And that's why the big international climate agreement is called the Paris Agreement, not the Copenhagen Agreement. And that story also dampened the enthusiasm for the Waxman, Markey, and Kerry Boxer cap-and-trade scheme in Congress. Though Democrats controlled both houses, too many Democrats quailed in the face of angry constituent telephone calls telling them no. Memo to you. Calling your senator or representative is always worth doing, even if you didn't vote for the guy or gal, just to get yourself on record. Facing this loss, Obama told his EPA administrator to find unilaterally that carbon dioxide is a pollutant and act accordingly, which the EPA did per Title 42 United States Code Section 7411D. And also as per Massachusetts versus EPA, which was a 5-4 Supreme Court case from 2007. This issue would probably have enabled any Republican except their nominee Mitt Romney to defeat Obama for re-election in 2012. Romney ran his campaign to lose. Senator Romney, if you can hear me, and if you care to dispute my assessment of your 2012 campaign, leave a comment. I don't delete or block comments unless they are profane or obscene, and I know you're not going to make that mistake. But I digress. Anyway, the issue certainly enabled Donald Trump to win election against Hillary Clinton, whom Obama picked by hand to succeed him. As we know, Trump not only withdrew America from the Paris Agreement, but he also curtailed the EPA's actions. He ordered this in 2019, according to the Federal Respondent's Brief. Now, as we also know, the Electoral College elected Joe Biden to begin serving as president on January 20th, 2021. On the day before the inauguration, the Court of Appeals for the District of Columbia vacated the EPA curtailment. But it stayed its vacating of the rule, apparently because the carbon emissions at issue were already within limits. Yet the federal respondents have not mentioned the reason for the fall in emissions. The reason is the overall curtailment of economic activity due entirely to stay at home and other orders relating to the virus that shall remain nameless. Well, you can understand that the petitioners do not want the EPA to stop any hope of economic recovery, as the country recognizes that particular virus is not the Black Plague. Now, the basic principle before the court is not whether carbon dioxide really is a pollutant. Indeed, the court has never appointed any special masters to look into that issue. Nor is it whether letting aliens apply for immigration visas while in the United States is wise or foolish. Those considerations are incidental. The point concerns the full extent of executive powers, whether under the Constitution or inherent. Let's stop right there to talk about expressed, implied, and inherent powers of government. Any government at any level and any branch of such a government has these three kinds of powers. Constitutions and laws of government of higher authority confer expressed powers. A government may infer implied powers from text that doesn't exactly expressly grant a power, but grants powers in related areas. Finally, any government claims inherent powers without which they simply aren't governments. Eminent domain, for example, is an inherent power. The Constitution does not forbid that, but it does set a limit on it. Raising and supporting armies is an expressed power, but raising and supporting air and space forces is an implied power, and taking care of veterans after their discharge is another implied power. Now, in this case, the federal government seems to claim an inherent power not only to regulate pollution, but to decide what is and what is not a pollutant. And they propose to do so apart from any reasonable legislative process. Commentary periods for rulemaking are not the same as legislative debate, nor do the people elect anyone at the EPA who make any such rules. All of which to say that presidents, going clear back to Nixon and arguably Franklin Roosevelt, have too much power. Executive orders can cut both ways. A president, by executive order, can unilaterally ignore his duty to take care that the laws be faithfully executed. Or he can make a new law and expect everyone to obey it as if Congress had passed it. A failure of faithful execution of law is at issue in Biden versus Texas. The consolidated EPA case is worse. I have talked before, I have decried quasi-legislative and quasi-judicial executive agencies. All right, yes, I heard you say quasi what? Quasi means partial. So quasi-legislative means having some of the powers of a legislature, but none of its limits. Likewise, quasi-judicial means having the order powers of a court, but not subject to the checks and balances that apply to the courts. This applies not only to the EPA, but also to any other regulatory agency. Can Congress really delegate to the president or an agency under him the power to make law? You can call your senator or representative, as I told you before, but calling the EPA administrator, that's a waste of time. Bureaucrats don't take telephone calls from those their rules affect, or they're not supposed to. Such an agency also has administrative law judges that judge whether you have broken the agency's rules. Such judges need observe no rules of evidence and are inherently partial to the agency's stated mission. So no hearing or trial before an administrative law judge can ever be fair. Two other columnists now hope the court will find against the government, specifically in the EPA case. Liz Peek wants to reserve to Congress the authority to decide what is and what is not a pollutant. Not only that, but she would like to see the debate on any kind of regulation back in the hands of Congress. Then all such rulemaking would take place in committee, with witnesses and the public permitted to attend. Public comment periods do not substitute for such open debate. In this connection, she quotes a very famous jurist. We expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. Unquote, Justice Antonin Scalia. Robert Romano, writing at Self-Reliance Central, sees a worse problem. In his analysis, the court has sometimes established reliance interests on rulemaking. The case he cites for that involved motor vehicle regulations, not environmental ones, but the principle remains the same. So the court needs to clarify the ambiguous state of executive powers. The country needs to know how far such powers go. The court's jurisprudence on executive powers has been all over the map, but today's Supreme Court has not been shy about revoking certain exercises of executive powers as invalid. We saw that in the New York gun case. Perhaps we'll see it again. If so, then the next time someone wants to denounce something as a pollutant, he'll have to come to Congress. That will mean testifying under oath and offering hard evidence for everyone to see. Links to the description of the article, to Title 8 U.S.C. Section 1225, to Title 42 U.S.C. Section 7411D, to my Climategate article from 2011, and to Conservative News and Views. I have another link to the awesome online store and to BitNext, as I also mentioned. And if you liked what you've heard, you can like this video. And on the end screen, I put in a subscribe link and also a link to my video about that New York gun case. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.